Good morning. I'll now call the meeting of the Special Committee on Reconciliation and Indigenous Affairs to order. My name is Lisa Semler, and I am the chair. I'm the MLA for Nuvik Twin Lakes and the chair of this committee. Our first order of business is to open our meeting with a prayer, and I will ask MLA Martselos to offer the prayer.
Thank you, Madam Speaker. May the warm winds of heaven blow softly upon your house. May the Great Spirit bless all who enter there. May your moccasins make happy tracks in midi snows, and may the rainbow always touch your shoulder. Amen.
Thank you, MLA Martselos. Our next item is to review an adoption of the agenda. Madam Clerk. Madam Clerk, I can't hear you.
Good morning. Sorry, I'm just...
Morning.
Okay, so our agenda today is prayer, which we've just done, review and adoption of agenda, declarations of conflict of interest, public matters, our presentation on the United Nations Declaration on the Rights of Indigenous People with Professor Brenda Gunn from the University of Manitoba Faculty of Law. And our in-camera matter is committee debrief, new business, parking lot, date and time of next meeting, at call of the chair, and adjournment. Thank you.
Thank you, Madam Clerk. Are there any additional or changes to the agenda from committee members? Seeing none, can I have a motion to approve the agenda as presented?
I'll move that motion, Madam Chair.
Thank you. MLA Simpson has moved the adoption of the agenda. Therefore, we will proceed to the next item. Are there any declarations of conflict of interest? Hearing none, I will move on to our next item. Today, the Special Committee on Reconciliation and Indigenous Affairs is receiving a public presentation on the United Nations Declaration on the Rights of Indigenous People. Our presenter this morning is Professor Brenda Gunn, professor at the University of Manitoba Faculty of Law. Welcome. Today's meeting is being live streamed on the Assembly social media channels. To respect physical distancing requirements, this meeting is being held virtually and attended by the Deputy Chair, MLA Ryland Johnston, and the committee clerk, Cynthia James, committee advisor, Kathleen Nosh, and committee support, James Thomas. I will ask the members and the presenter to please wait to be recognized by myself, the chair, before speaking, and to direct all comments and questions and remarks through me. And I will now ask the members to introduce themselves. First, those who are calling in virtually, and then those in the room. And I'll start with Ms. Martselos.
Good morning. Good morning, Madam Chair. This is Frida Martselos, the member for Tabacha.
Thank you.
I'll go next, I suppose.
Yeah.
Good morning, everyone. My name is RJ Simpson. I'm the MLA for Hay River North, as well as the Minister of Education, Culture and Employment, and the Minister of Justice. Thank you.
Thank you. And I'll start in the room with our Deputy Chair and then go around the table. Thank you.
Thank you, Madam Chair. My name is Ryland Johnson. I'm the MLA for Yellowknife North, and happy to have you here today, Professor Gunn.
Good morning. My name is Caroline Cochran. I'm the MLA for Range Lake. I'm the Premier of the Government of the Northwest Territories, and I'm the Minister responsible for the Executive and Indigenous Affairs and the Minister responsible for the COVID Secretariat. And I'm more than honored to be here to listen to your presentation.
Good morning, Caroline Wozniak, MLA for Yellowknife South, Minister of Finance, Minister of Industry, Tourism, Investment, and Minister responsible for the status of women. Very much looking forward to your presentation.
Thank you, member. MLAs on the call or virtual that can introduce themselves, please.
Thank you very much, Madam Chair. My name is Caitlin Cleveland, and I'm the MLA for Cam Lake.
Welcome. Professor Gunn, please proceed with any opening remarks that you would like to make, and then you can proceed with your presentation.
Thank you. Good morning, everyone, and Madam Chair and committee members and MLAs, and really honored to be here with all of you from Treaty 1 territory and the homeland of the Métis, my home territory, and currently my home office in Winnipeg. I'm really excited to get to speak to all of you about the UN Declaration and some of the thoughts and reflections I have on implementation. But I did just want to acknowledge all the challenges that we're having generally and the additional challenges that I've heard with the flooding up north. And just to know we are thinking about you and hoping for the best outcomes possible in these really trying times. So I do have a PowerPoint presentation I'm going to attempt to share. We practiced this once, but if there's anything I've learned over a year of online, just because you've done things once 10 minutes ago doesn't mean it'll work this time. But we're slowly teaching this old dog some new tricks. Okay. It's telling me I'm sharing and I can no longer see people's faces, so I'm hoping. Okay. So I'll just, excellent, thank you. With your indulgence, I'll just begin. I'm going to try to keep my remarks ideally in the 35 to 40 minute time frame. I know it's hard to sit online and listen to a talking head for a long period. So I'll try to keep my remarks short and on topic, but I'm going to start just by talking a little bit about why there's a UN Declaration and why I think it provides a framework for reconciliation. I'll talk a little bit about what's contained in the Declaration and how to go about interpreting it. And then I'll talk a little bit about some of the opportunities and challenges of implementation, some of the different avenues that are available. And then, of course, I look forward to hearing all of your questions. So first off, I think it's important to know that we do have a Declaration on the Rights of Indigenous Peoples, and that, of course, probably many of you know that the Truth and Reconciliation Commission of Canada did refer to the UN Declaration as the framework for reconciliation. And so when trying to understand what was it that the TRC saw, I tend to turn to 4 preambular paragraphs of the UN Declaration. So the very first one affirms that Indigenous peoples are equal to all peoples while recognizing the right of all peoples to be different. And I think this is important because there are many instances in Canadian law where Indigenous peoples have not been recognized as peoples or as being equal, right? So there was many ways in which Canadian law is based on ideas of Indigenous peoples as fierce savages whose occupation was war, right? These are the words of Chief Justice Marshall in the 1820s case, and is really the foundation for a lot of Canada's assertion of sovereignty over the land. So I think this recognition that Indigenous peoples are peoples is really significant. The UN then expresses concern that Indigenous peoples have suffered injustices as a result of colonization and dispossession of lands. And so recognizing in Canada the impact of the colonial process, particularly noting the challenges that Indigenous peoples face when they are removed from their lands, territories, and resources. And we don't always necessarily need to think of Indigenous peoples being physically removed from their lands, but even where their access or control or ability to use the resources have been impacted. So once we recognize that Indigenous peoples are peoples and that colonialism, in particular the removal of lands, has been to the detriment of Indigenous peoples, the UN then says that they are convinced that the recognition of rights will enhance harmonious and cooperative relations between the state and Indigenous peoples. And I think this is really important because one of the things that I have consistently heard from certain sectors in the last 10 to 15 years is the idea that somehow Canada is a peaceful, good country, and that if we implement the UN Declaration, that we're going to upset the status quo, which they view as being good, and that somehow it's going to tear Canada apart, right? So this concern that somehow implementing rights is going to tear Canada apart, I think is addressed in this preambular paragraph. The idea that Indigenous peoples, if we want to reconcile with Indigenous peoples, we have to do so now on the basis of rights recognition. And that doing so shifts the relationship from a colonial one, where Canadian governments assert jurisdiction and control over Indigenous peoples, to a new relationship based on the principles of justice, democracy, respect for human rights, non-discrimination, and good faith. And then finally, and I think important to today's conversation, the UN solemnly proclaims the Declaration as a standard of achievement to be pursued in the spirit of partnership and mutual respect. And so I think this is important for all Canadian governments to remember, that they cannot unilaterally implement the UN Declaration on their own, but rather realizing the rights of Indigenous peoples and changing and continuing to move that relationship forward requires the participation of Indigenous peoples and for their full involvement in that process.
Sorry, Professor Gunn?
Yes?
I'm not sure if you're having to manually change the slides, because all what you can see is the first slide.
Oh.
If it's not changing on our side. I'm not sure.
This is good to know. Okay. I guess we didn't test moving through this. I'm going to... does our tech support have any idea I have... I can't... Do you now see a screen that says thematic clusters?
Yes.
Okay. I've changed time data. I'm not just sharing the file. I'm now sharing my entire computer. So we'll see if that works. So I'll just go back a slide then. So the slide was just showing the preambular paragraphs there, but I did speak to them. So the next are the thematic clusters that are included in the UN Declaration. And so in the UN Declaration, there's, of course, 46 articles, and I don't want to spend time walking you through them one by one because that wouldn't be interesting for anyone or a good use of time. But I thought it might be helpful to just remind us of what are some of the areas that are covered. So Articles 1 and 2 deal with equality and non-discrimination. And then throughout the Declaration, we see reference also to Indigenous women's, children's, and elders' rights. Articles 3 and 4 talk about self-determination and self-government, and we have provisions that deal with Indigenous institutions as well. Then we move on to provisions that look at the right to life, integrity, and security of the person. There are many provisions that deal with the right to culture, religion, and linguistic identity of Indigenous peoples. There is a right to education, public information, and media. So right to education in one's mother tongue, a right to have public information accurately reflect Indigenous people's aspirations, a right to Indigenous media. We, of course, have provisions on the right to participate in decision-making in free, prior, and informed consent. These are provisions that get a lot of attention lately, but I don't think we want to solely focus on those aspects. There are provisions that deal with economic and social rights, including areas of employment and health. There are provisions that deal with the rights to lands, territories, and resources. And then finally, a provision that deals with treaties, agreements, and other constructive arrangements. So you can see that the provisions are quite broad and really encompass all aspects of Indigenous people's lives. So this slide here, now I'm hoping you're still seeing a slide that says understanding the rights.
Yes, we do.
Okay, excellent. I think we maybe have this working. So I just wanted to highlight briefly when we talk about the rights in the UN Declaration, that when we're trying to understand, well, what do those mean? You know, especially when we're thinking about implementation, we have to try to understand. And I just want to remind everyone that, you know, understanding what the rights are is not necessarily as simple as just reading the 46 articles and the preambular paragraphs. That we want to remember that the rights in the UN Declaration build on existing human rights treaty obligations. So Canada is a party to numerous human rights treaties that do recognize the rights of Indigenous peoples. And so the example I use is some people have been trying to sort of say that FPIC is new and that we, you know, should rely on the duty to consult. But I think it's important to remember that FPIC is not new in international law, that in the 90s and 2000s, before Haida Nation came out, we do have international human rights law recognizing the right of Indigenous peoples to free, prior, and informed consent through interpreting human rights treaties such as the Convention on the Elimination of All Forms of Racial Discrimination and the International Covenant on Civil and Political Rights. Also, when we're thinking about implementing and understanding the rights of Indigenous peoples, we have to remember that the rights are recognized, are inherent rights, and are grounded in Indigenous peoples' own customs, laws, and traditions. And so the example I have on this slide is that when we're trying to understand, well, what are the rights of the Métis people to their lands, territories, and resources? The answer isn't necessarily contained in the UN Declaration. It just sets out the basic parameters, right? A right to own, occupy, use traditional territories. Well, how do we find those lands? To understand that, we have to turn to what are the Métis people's own laws that say what territory was theirs, how did they exercise jurisdiction, what are the basic rules that are related to those laws, right? So understanding the rights also requires us to consider and understand Indigenous people's own custom, laws, and traditions. And then the next point here is just that when we're looking at understanding the rights, we have to remember that all rights apply equally to men and women. This is stated in Article 44. But we need to make sure that we take a gendered approach to implementing all rights in the UN Declaration, right? So a provision that speaks generally to the state's obligation to respect treaties is it must also have a gendered lens to it. So making sure that Indigenous women are participating in decision making. And then the other provision that does specifically mention Indigenous women is, of course, the need to address the violence against Indigenous women. And so I wanted to highlight both the specific provisions, but also remind us that we want to ensure that the process of implementation equally benefits Indigenous women and girls as well as, and the whole communities and nations. So what are Canada's obligations in relation to the UN Declaration? Well, since the Declaration is a human rights instrument, Canada is obligated to implement the UN Declaration, and this is based in the UN Charter. Right, so in order for Canada to be a member in good standing of the United Nations, they have to uphold all of their obligations, which would include human rights obligations. And where do we go to understand Canada's obligations in relation to human rights of Indigenous peoples? The UN Declaration can be really instructive in that matter. Importantly, the UN Declaration sets out basic minimum standards. So we, of course, are able and welcome actions that move beyond the minimum standards, but we look to the UN Declaration as that baseline for government action to ensure that anything that the government doing is meeting that floor, right? So it's setting a floor, not the ceiling, so governments, of course, can move beyond. Next, when we talk about implementing human rights, we must remember that human rights are indivisible and interdependent. So this means we can't pick and choose implementing rights. We can't say that, we're only going to focus on implementing this set of rights and, that other rights are unworkable. We need to recognize the way that in order to exercise economic and social rights, for example, requires those political and civil rights, that participation in decision making. And finally, I want to highlight that the UN Declaration itself has a non-derogation clause, and this is in Article 45, where it states that nothing in this declaration may be construed as diminishing or extinguishing the rights of Indigenous peoples that they now have or may acquire in the future. And I think this might be relevant in the Northwest Territories context, of course, because of the modern treaty tables and land claims and self-government agreements, where some people may be concerned about, is implementing the UN Declaration going to undermine those modern treaties? And so the UN Declaration is really clear. And I mean, this is a basic principle in human rights. It's about raising up the standards, right? And so implementing the UN Declaration cannot lead to the derogation or abrogation of any existing recognized right, including those in treaties, self-government agreements, land claims, etc. So when we talk about implementing the UN Declaration, I think before I get into some of my ideas on how we can go about implementing the UN Declaration, I just thought it might be useful to do a really quick International Law 101, and I'm sure many of you are excited to have a foray into international law classes that I teach. But there's 2 or 3 sort of basic things that we want to understand. The first is that Canadian courts have said that human rights treaties, so I use the example of the Convention on the Rights of the Child, must be implemented through domestic law, either implicitly or explicitly. So that's the technical rule, that for those international human rights treaties to apply, they must be implemented. Now, I should note that Canada has reported internationally that they have implemented all of the treaties. They do this in their periodic reports before each of the treaty monitoring bodies. Sometimes Canada has claimed domestically in litigation that a treaty can't be relied on because it hasn't been implemented, but I think we want to be cognizant of such claims as being contradictory to what Canada has reported internationally. And it's also worth noting that the Canadian courts have said that even unimplemented treaties may still have legal effect in Canada. And so we sort of have the technical rule and then the practical approach the courts have taken. In relation to customary international law, the courts have said that customary international law applies directly in Canada unless there is a law that expressly states otherwise, right? So anything that's considered a rule of customary international law is part of Canada's international law, unless Canada or a state has taken actions to say that that rule doesn't apply or that a different rule applies. And so I've just explained here that where rights in the UN Declaration express rules of customary international law, those would have legal effect in Canada. And there are strong arguments being made that the rights in relation to lands, territories, and resources, for example, are now part of customary international law. And then finally, I just want to highlight a third way that the courts have begun to talk about international law's application in Canada, which is the presumption of conformity. And this is the idea that the courts strive to interpret domestic law in line with Canada's international human rights obligations. right? So what we've seen are a few examples where the courts look at international obligations like human rights treaties, declarations, and interpret Canadian law in such a way as to help Canada meet their international obligations. So with all of that, then what are the options and potential approaches to implement the UN Declaration? Well, one way would be to pass legislation that implements the UN Declaration. Another approach could be to expand the interpretation of Section 35. So this would be not sort of fitting the UN Declaration into the narrow scope of the current Section 35, but actually using the UN Declaration to broaden or expand our understanding of what are the rights, the Aboriginal and treaty rights that are recognized and affirmed in Section 35. We could say, well, at a minimum, Section 35 would include all of the rights articulated in the UN Declaration. Another approach to implementing the UN Declaration, one that we're starting to see in Canada, is litigation. So we are seeing more Indigenous peoples referring to the UN Declaration in litigation against Canada, and we're seeing some take up by the courts on this. The UN Declaration can also be implemented through negotiations, right? So this can be self-government negotiations where any sort of negotiations start with the UN Declaration as the baseline, so that you may not need to necessarily negotiate, what is all included, that you could start with the UN Declaration as a baseline and then work to explain what does that look like and how do we make that practical on the ground. Implementing could also be done through a national action plan, right? So a coordinated approach where, you look at the different rights and you talk to the different Indigenous peoples and you come up with an approach to look at implementing. And then I just also thought it might be worth highlighting that implementation can, and in my opinion, should also happen in Indigenous governments as well. So I do hope that Indigenous people's own governments continue to uphold the standards set out in the UN Declaration. And just a reminder here again that regardless of the option that we choose for implementing the UN Declaration, and I should say they're not mutually exclusive. Of course, you can use all of the approaches, but it's important to understand that implementation must uphold those minimum standards, right? So while we talk about implementation, or domestication is the word we use, is taking that international law from the UN level and bringing it into Canadian law, we have to make sure that we don't water down the standards. We're applying those standards in Canada. And so I just thought I would throw in a couple of examples that we are seeing the courts use and begin to refer to the UN Declaration, mostly through the presumption of conformity. But I will say that there continue to be challenges on using the UN Declaration in litigation because I think domestic lawyers, lawyers who are trained in the common law, and judges do not always have a good understanding of international law and how it applies in Canada. And so we continue to see some judges making some fundamental errors in international law. Or what we're seeing even more frequently is the idea that the court simply says a party pled it, but they make no comment on it. And so I do think that while litigation is an option in Canada, it's one that we're kind of struggling with as judges don't, and lawyers, I don't think fully understand how to use the UN Declaration in Canada. We are seeing some legislative efforts. So we, of course, have the federal bill, and I'll maybe speak to that for just a brief minute or two. But we are seeing some references to the UN Declaration in preamble of federal legislation, where we begin to think about how our domestic legislation could be read in line with the rights set out in the UN Declaration. We also have the BC legislation, and then there's also some references to the UN Declaration in the Manitoba Path to Reconciliation Act. So I think I'm making okay time. I'm just going to set out really quickly what the federal legislation does, only because I think I'm not necessarily recommending it as a model, but I think to understand the wisdom or why is it structured the way it is might be useful to think about. So the first thing that Bill C-15 does is clarifies that the UN Declaration applies in Canada, right? So it's really helpful in that area of where people want to use it in litigation. It's useful to, if we all had that starting point that the UN Declaration applies, so you don't have to spend that time trying to explain the rules of international law or learn those. We can just sort of take it as our starting point that it applies. So that's useful. The second thing it does is that it requires Canada to review laws to ensure consistency with the UN Declaration, right? So it takes a survey of what's happening and helps understand where we are in relation to the UN Declaration. Then it commits Canada to develop an action plan to implement the UN Declaration. And then I think importantly, it's not just develop a national action plan, but it has an accountability and transparency mechanism through the periodic reporting, right? So requiring the government to report back on what the government is doing to implement the UN Declaration gives us that opportunity to provide some checks and balances and to understand what is happening, because it's not always easy to know what the government is doing. And then finally, of course, the Bill C-15 also has a non-derogation and abrogation clause. So recognizing that implementing the UN Declaration, of course, can't undermine existing constitutional rights. Again, human rights is about elevating, not taking away rights. So from my perspective, what are some of the steps that are needed to begin implementing? I think the first thing that has to happen is we have to understand what the UN Declaration is. What are those rights? What are the standards in relation to lands, territories, and resources, to participation in decision making? Again, remembering what I said earlier, it may not be as simple as just reading the 46 articles. There may be some additional background information to understand how the right has evolved internationally. I think in the Northwest Territories context, and I think in federal provincial context is thinking about jurisdiction, right? So implementing the UN Declaration is not something that any government in Canada can do unilaterally. So once we understand what is contained, I think governments then need to look at their own spheres of jurisdiction to see which areas actually fall within the government's own jurisdiction. And recognizing that I think the federal government doesn't have all jurisdiction over all areas necessarily. I don't think Northwest Territories necessarily has jurisdiction, nor any province. Once you understand what areas fall within your jurisdiction, I think the next step is to begin to review existing laws, policies, and practices, right? To really see where are you meeting and maybe exceeding the rights that are set out in the UN Declaration? And I think there's a lot of wonderful things happening up in the Northwest Territories, that there may be areas where you are already meeting or exceeding the standards, but then also to identify areas where there may still be work to be done. And I think once you understand the extent of the landscape, right, sort of seeing where things are, then it's about working with Indigenous peoples to make a plan to implement the UN Declaration and making sure there's opportunities for Indigenous peoples to be full participants in that process of making the plan and implementing the plan. So those are sort of the steps that I think are part of the process to implement. I do think there are some opportunities that implementing the UN Declaration brings us in Canada. I think this part of it moves us back to that idea of implementing the UN Declaration as a framework for reconciliation is about moving beyond an us and them mentality. So depending on which side of the us or the them you are, I think there are many examples where we still see a divide. And so the process of reconciliation and working together to implement the rights can really help us come up with a shared vision. I think this process begins to help recognize that Indigenous peoples are partners in confederation, right? That Indigenous peoples are not problems to contend with, issues to be resolved, or risks to be managed. If we recognize that Indigenous people are founding partners, we have to recognize that they are decision makers, not simply stakeholders, but they are actual decision makers in relation to their lands, territories, and resources, for example. Implementing the UN Declaration, I think, is also a great way to bring together, and in some of my work, we've used the metaphor of braiding Canadian, international, and Indigenous law. The idea, of course, of braiding, meaning in order for a braid to work, all strands have to be of equal weight and value, and that by bringing the three legal traditions together, you would end up strengthening all three of them. Opportunities can include a legislative framework. It doesn't have to include, but I think there's definitely opportunities that can help in certain jurisdictions, at least, to have a legislative basis. Others, maybe it works to have a policy. But I think some of our jurisdictions need a stronger commitment, and a legislative framework is useful. Implementing the UN Declaration also can help address the gendered aspects of colonialism, and I think we see some of this in even the report of the National Inquiry into Missing and Murdered Indigenous Women and Girls. If we focus on looking at human rights and upholding the rights, and also implementing the UN Declaration really does help us achieve reconciliation. And I think brings us back to fundamental treaty relationships, right? And really understanding that nation-to-nation relationship, and that different governments will have jurisdiction in their own areas, and that they're sovereign in those areas, right? And there should be non-interference and but cooperation and working together. So I think there really is a lot of opportunities and benefits to implementing the UN Declaration. There, of course, are challenges, and I think I've touched on some of these that include understanding the UN Declaration in the context of international human rights law, right? I've heard many people say we shouldn't, FPIC is unworkable, that we don't know what this new standard means. We already have the duty to consult. We have good law here. Let's not upset the apple cart for some unknown. Well, just because some people in Canada don't know those standards don't mean they're unknowable. There's lots of places that provide that context. We have to understand the international and legal character of a resolution, and many lawyers and judges don't, so that can be challenging. I think we also have a challenge of moving beyond rhetoric of, lots of people want to talk about the principles of the UN Declaration, but we have to remember these aren't just principles. These are fundamental human rights, basic human rights that we say all peoples in the world are entitled to human rights. So I don't want to undercut what is set out in the UN Declaration by simply talking about principles, but really recognizing the rights. And I think that requires government to change how they make decisions in some circumstances. It requires training so that governments and ministers and ADMs understand what those rights mean. We have to ensure that Indigenous women are involved in the process, that their perspectives are included and the issues that they're concerned about are addressed. I also think really importantly, implementing the UN Declaration requires us, again, to move beyond that dichotomy of civil and political rights versus economic, social, and cultural rights. Again, interdependent and indivisible means that we have to appreciate and work to implement all rights. And so I'll just end it there. And I did just on this last slide put together a few resources that might be useful. There is a handbook that was developed for parliamentarians at the UN, and so there's a link there. There is a monitoring mechanism for the UN Declaration coming out of Aotearoa, New Zealand, so community-based, an iwi-based implementation where the local communities are monitoring and report regularly to the UN. There's the Indigenous Navigator, which is where there's actual indicators that are developed on what does implementation look like and how to start tracking implementation. I've also developed a handbook on understanding and implementing the UN Declaration that people continue to find useful. And then finally, I thought I would just also, if you're interested in learning more about some of the substantive areas of the UN Declaration, the expert mechanism on the rights of Indigenous peoples, one of the UN expert bodies that provides studies and advice on implementing the UN Declaration. They've done studies on FPIC, on lands, and the right to participation in decision-making, on culture. And so I provided a link to that, to the webpage so that you could see the different studies there. So I'm going to attempt to stop sharing now. And I will leave my presentation there, and I look forward to the questions.
Thank you, Professor Gunn, for your presentation. I will now allow questions or comments from committee members. I'm going to start with those who are in the committee room. Carolyn Wozniak, do you have questions?
I get to go first today. Thank you, Madam Chair. Yes, I have questions. I guess I wanted to, on one hand, underscore a bit, or ask you perhaps to underscore rather, Professor, the non-derogation concept. And, and maybe I'll preface it a little bit. We've obviously had several presentations now, everyone different and everyone useful to us. I've been very grateful for each and every one of them, including yours. But each one is presenting, some in particular are presenting the declaration and its contents in a different framework. So, we're hearing at the beginning perhaps more about the declaration as being more set in standards and a bit more legalistic, a bit more grounded in what can or can't be done or what can or should be done, as opposed to the presentation you're giving today, which I thought was much more rights-based and inherent rights-based. And it's an interesting contrast to me. So I'm wondering if you could, speak to a bit, and I suspect this is probably something that you deal with in an academic circle, but that feeling of, is the declaration something that needs to be, very specific and contained and, parsed out even, if you will, where, you might be said, well, we're already doing X, Y, and Z, therefore we've achieved the goals and therefore we've done enough. Or is it something that is, again, if it's rights-based and it's and there's a non-derogation concept, can we continue to aspire to do better than what we're doing? It's how do we look at those two ways of thinking of what we have here? So there, I'll turn it over at that point. Thanks.
Okay, thank you for your question. I will do my best to answer it. And I just, I want to seek clarification just because I can rattle on for a while. I'm used to committee meetings that have strict time limits for questions. I assume there's a touch more flexibility here. We're not sort of limited to the 2 minutes for the minister's questions and responses that we may be in other contexts. Is that?
Yep, you can just answer. Okay.
Okay, yes, I will try to be on point and succinct. I'm going to maybe start by answering your question in a way that's uncomfortable to me, and I'm going to speak to my credentials. Because I think it's important to understand that my presentation comes based on almost 20 years of working on international human rights as they relate to Indigenous peoples and the domestic application of those rights. So I don't claim to be expert in many things in life, but I will say it's been almost 20 years since I went to law school, and I first, in 2002, first year in law school, that I learned about the UN Declaration, and I got connected with some of the world's leading experts, and I began studying and learning about these rights. So the opinion that I'm providing is based on those years of experience. It comes from, I did my Master's of Law with James Anaya, who is the former Special Rapporteur on the rights of Indigenous peoples. And I worked with him on land claim cases in Belize, for example, and in Nicaragua. I've also worked on international human rights cases in Guatemala on cases of genocide. I have studied and worked with Indigenous communities in Australia, and I've worked in Australia, and I work in New Zealand, and I've worked with academics and communities in New Zealand as well. So I've spent a lot of time thinking and learning about these things, and it's come over an extended period of time. I also spend a considerable amount of my time and energy participating in international Indigenous rights meetings, so that I attend a lot of the UN meetings on these subject matters of the permanent forum and expert mechanism. I attend Canada's reviews before international human rights treaties. So I've heard and I've spoken to many of the experts who are charged with monitoring Canada's implementation and talking to them about what's happening in Canada and the expectations. So my perspective, I think, is well-grounded. And something that I've spent a lot of time thinking on. And I think where that then gets me is to really understanding human rights as rights. It is somewhat untasteful to me when people try to undercut the UN Declaration or other, I guess the UN Declaration in particular and the rights set out in it, by using words along the lines of our former Prime Minister about aspirational or principles or ideals. If we are a country that respects human rights, and we want to be a country that is upholding human rights, we have to stop treating Indigenous peoples as lesser peoples and as having not the same human rights. I mean, they look different, right? Of course, different people exercise human rights in different ways, but they are rights, they are obligations. We have to, so to say that a human right that has been accepted by the world is unworkable or is going to take away from things is just, it's really saying that Canada should not respect fundamental human rights. And I think that's really problematic. And I think we want to recognize those statements for what they are. They're saying that we should not recognize human rights for Indigenous peoples. And sometimes that reason is because it may impact Canada's economic bottom line. And I'm really concerned that that's our sort of measure. I also, to relate this back then to non-derogation, I want to reiterate that human rights is about raising standards, right? So where a state has already recognized rights, and if those exceed the UN Declaration, you would never say implementing the UN Declaration, oh, sorry, you have too many rights. Your rights are really good. We got to wheel those back, right? Like, that's not what human rights is about. So I think we want to make sure that we want to be cautious, and we want to make sure that we don't directly or indirectly through implementation undercut existing rights. But we really need to recognize that where rights are already recognized, we work from those, right? That we're setting out just a new floor, right? We're just trying to raise the floor. And if people are already there, that's fantastic. I hope that answers your question somewhat.
Thank you, Professor Gunn. Minister Wozniak, did you have a follow-up?
Yeah, thanks, Madam Chair. And Madam Chair, and Professor, yeah, that is where I wanted this to go without being too specific about it. But it's that idea that the tension that there seems to be around, is the declaration an aspirational document, Or is it in fact a statement of law and a statement of something to which we are actually bound already, and that we have to now figure out how we're going to respond to the fact of being bound by this document? So that was very helpful. I guess then, if I'll take up your last statement, if I may, where rights are recognized, we start from those. And I think there's sometimes a challenge in that what one group thinks has been recognized, another group says is not actually recognized. So, you may have one party saying, well, we've already done X, and this right has been recognized, and it's recognized in this piece of case law, or it's recognized by, the way in which we have designed a certain system or a policy, whereas those who are impacted, and I'm not trying to be too general, but, indigenous groups would say, no, you have not met the right standard. No, you have not actually achieved this. So even the starting point is difficult to get to, and we can't agree on what rights are recognized. So that's my last question. Our second question is sort of how do we even get to that starting point when we often are still at fundamental disagreement? Thanks.
Yeah, thank you for your question. There's sort of a two-pronged response, I think. One is we have to understand the international human rights standards, right? Which again might not be as simple as like reading what the Declaration says. So if we talk about participation in decision making and free, prior, and informed consent, which tends to be one of the areas that several people have expressed concern about in Canada, we can look to the study, for example, by the expert mechanism. They are some of the world's experts on this, and they've provided some guidance and some information. So we can look there as one starting point for understanding. But again, we also have to recognize and look to Indigenous people's own customs, laws, and traditions, right? So in relation to decision-making and free, prior, and informed consent, the UN Declaration, for example, is really clear that Indigenous peoples get to choose their own representative bodies, and that when the government consults and engages Indigenous peoples in that decision-making process, they have to ensure that Indigenous peoples have sufficient time and resources to do their own internal decision-making processes, right? So in order to know whether any government in Canada is upholding those standards, we have to turn to the Indigenous peoples, right? And I'll just use my own peoples, right? Métis. So Métis, who do you want as your representative institution, right? This is one of the challenges we've seen in relation potentially to Bill C-15, is concerns that Canada focused too much of its consultations with the national Indigenous organizations, and some people have said that Canada should have engaged directly with the rights holders, right? So step one, Indigenous peoples, who do you choose to represent you in these processes? And two, what are your own internal decision-making processes that you need to engage with, right? And is the framework that we've set out creating that specific space? So I agree, it is hard to get to just sort of knowing what that baseline is, because it requires you, and not you specifically, but requires governments to look beyond just Canadian law to understand if they're meeting those standards.
Thank you, Professor Gunn. I'll now move on to Madam Premier. Did you have questions?
Madam Chair, yes, I do. Okay, I have two, actually. One is within the Northwest Territories. I think you've identified some of them. We do have modern treaties. We're in a little bit of a dilemma in that one of the priorities of this Assembly is to implement the United Nations Declaration on Indigenous Peoples. However, we've been moving towards land claims and self-government for quite a few years, and so the Indigenous governments with modern treaties are saying, implement modern treaties, that is the way to go. And the Indigenous governments that don't have modern treaties are saying, scrap modern treaties, we're jumping on United Nations Declaration, which is causing me some issues. In the Northwest Territories, we also have different things. I know you're talking about we're talking basic human rights versus principles, but I do think that sometimes principles and are important when you're talking about human rights. So we do have some things like our Intergovernmental Council, which we're equal partners in. The GNWT is not the lead. We're equal at that table, and that table discusses the royalties within the NWT. We have a legislative framework that we just signed with all the Indigenous governments at the intergovernmental table that looks at legislative changes for land and natural resources. And we're just forming a multilateral table for Indigenous governments and the GNWT to talk about social issues and program delivery. So I guess my question with that is how am I going to now, because I do believe there's both. I believe that in my heart that we can have, the concept of the declaration plus also have modern treaties. But I'm at a standstill where people are now waiting and saying, am I going to get more from the United Nations Declaration? And in my heart, I'm feeling that's not the way to go. My heart is telling me that treaties is the way to go. And I'm hearing that from the Indigenous governments. What is your recommendation around that? Do I need to let it go and respect that people are, work towards this declaration, or do I still keep trying to work towards modern treaties? Maybe a tough question, but that's where I am.
Thank you, Premier. I enjoy the tough questions. I think it's a really good one, and it's one. So I'm not a politician, so it's easy for me to say I don't actually think it's that complicated, but I'm not in your chair. So, but what I will say, maybe an overly simplistic answer, is self-determination is about people deciding for themselves. Right? So we shouldn't impose the UN Declaration on nations who don't want it. That's not self-determination. That's not implementing it. I think part of the answer can be understanding priorities and approaches. And I think it's fair for nations who have a self-government agreement who want to say, our priority right now is to work towards fulfilling our self-government agreement. And we don't want to spend the time or resources looking at the UN Declaration. However, I do think that there may be times where implementing a self-government agreement becomes a point where there's a lack of clarity or an issue of what did we actually agree to. And I think this comes back to Minister Wazonik's question about what did we agree to, right? And if anything like that were to happen, the UN Declaration may become useful in saying that, okay, well, we're not sure, but here's a baseline that we could say it has to mean at least this. Right? And it could be something that could be worked from. But I think from my perspective, I don't think it has to be either or. And I don't think we have to either all be on board or all not on board. I don't think there's a need to have the approach be for everyone to be the same. And I think this is part of what is even contemplated within the UN Declaration, right? How implementing the UN Declaration may look for Indigenous Nation A might be different than what it looks like for Indigenous Nation B. And Indigenous Nation C might actually say, that's not our priority right now. And I don't think the government has to sort of do it for everyone or no one. I think there is opportunities to be more specific and respect the self-determination decisions of the peoples where they come to. I think it is important, though, in making those decisions that nations understand the non-derogation clause in the UN Declaration. I think in the South, at least, I'm hearing concerns that people are saying, for example, we shouldn't move forward with Bill C-15 because it's going to undermine Indigenous people's rights or treaties that we have down here. I live in Treaty 1 territory, and my partner's from a Treaty 6 community. So, I think it's important that people understand when they're making those decisions about whether to engage in the processes that the process can't be used to undermine an existing treaty, right? So that it's not going to, that engaging in that process isn't going to undercut the treaty.
Thank you, Professor Gunn. Madam Premier, did you have a follow-up?
Yes, thank you, Madam Chair. Thank you for that answer. The more difficult one for me, and it might be easy for you, is when you talked about the gender focus within treaties, within United Nations Declaration, etc. Now, you also talk about non-interference, you talk about self-determination, etc. Within the Northwest Territories, we do have some Indigenous governments that are very patriarchal focused. Had lots of comments since we've been in this assembly, first assembly with gender parity, 9 women elected out of 19 legislators, 5 women on cabinet. But I've heard over and over from Indigenous governments that the reasons we have any troubles, whatever it may be, is because there's 5 women on cabinet. So I agree with you that we need to have a gender focus, but how do we do a gender focus and still respect the self-determination and and not imposing what we want on Indigenous governments? So, thank you.
Thank you, Premier. That is an incredibly challenging problem, and I think you are hitting on all the right issues, right? That we can't impose standards, but this is where some of my work, I try to urge and really work with Indigenous governments and sort of, especially Indigenous governments who are pushing for Canadian governments to implement the UN Declaration. I kind of work to remind them that these are also standards we should be governing ourselves by, right? Never mind being worried about whether the charter is going to be imposed on you, right? Like if these are our rights, and they should be respected by our governments and the Canadian governments. And I think that's really important. But I think there could be a role for Canadian governments to support Indigenous governments in realizing some of those standards, including gender equality standards. I'll use the example of just the Canadian government has done a lot of damage to our First Nations down, in Manitoba, across the country through the Indian Act. The gender disparities and the gendered impacts of colonialism are just so clear, right? When women weren't able to vote or stand up for band councils until the 1950s, like that's a huge impact. And so I think, for example, I think Canada has an obligation to support nations in addressing those gendered impacts and working through some of those things. So I think you're correct in that we have to tread carefully and not sort of impose things on, but figure out where the support is and remind our governments of fundamental human rights. And I think the other component to this is Indigenous governments and laws have been under attack for a long time in Canada. And so I think it's fair that sometimes our governments get very protective and don't want anyone from outside telling us how we should be because there's been so much damage done. So understanding that protective nature and figuring out ways to say that, even if traditionally an Indigenous government was patriarchal, Indigenous governments, like all governments of the world, continue to evolve as our understanding of fundamental human rights evolve. And we need to make sure we create space in Canada for Indigenous governments and laws to continue to evolve. I think John Burroughs and Val Napoleon have done some excellent work in this area. But we also have to, I think, recognize and accept responsibility of Canadian governments for how they've contributed to that digging in, right? Even if you think about the Section 35 test for Aboriginal treaty rights, Vanderpeet says it has to be central and integral to the distinctive culture since contact, right? So we've set up a system that doesn't allow for governments and laws to evolve and grow and meet new standards. So we have to address some of those systemic issues that really prohibit governments from evolving and meeting those standards.
Thank you, Professor Gunn. I will move to Ms. Marcellos. Do you have questions?
Thank you, Madam Chair. I just have a couple of comments. One of your slides was really important to me because you state in that one slide that government employees need training and clear direction from ministers, deputy ministers, and ADMs. I just want to know why you made that statement, because that seems to be a major problem within any kind of government. I find that you can go to a minister, or you can go to and you figure you got your clear direction with the first statement, and then you have to go back about 5 times before you actually get it done. And so there's not really clear direction given to within the policy, even if it has to do with affirmative action, which the territories is majority Aboriginal, and some of these, and there's lots of gaps. We all know that, and we're still dealing with all these issues as Aboriginal people with even the hiring process. So, it was really interesting that you had this one thing in one of your slides, and I just want you to clarify that one statement you made in that slide.
Sure, I can do my best. And my apologies for not fully appreciating the context in which the government of the Northwest Territories operates, including the process and structure. So I'm not sure if I'm speaking in a way that's relevant. But I will say, in my experience of doing training with governments in Manitoba, with federal departments, as well as speaking with politicians, I've noticed often sometimes a disconnect. So sometimes we hear at the political level support for, I'll say, the UN Declaration. But then when it comes to working with the people who are charged with implementing programs, they do not understand what that political statement means or how they actualize that. And sometimes it's the converse, right? You have people who are charged with programs who want to implement the standards set out in the UN Declaration and really engage in robust decision making and planning with Indigenous governments, but they don't have that direction from their manager, from the director, from their ADM, from the minister. And so it becomes really challenging to move things forward. And then sometimes you kind of get it from both ends, but there's somehow a gap in the middle at the director manager level. And so the comment went to, I think it's important that everyone understands what the standards are, right? So the politicians are saying, we support the UN Declaration, understanding what it is and what that means, and then making sure that the people who are charged with implementing programs and policies also understand what it means to support the implementation and can actually work with that with clear direction. So that was sort of the situation that I had experienced, that I had included that in.
Oh, sorry, Ms. Martinez. Did you follow up?
Yeah, that's it's interesting. We're going at the higher level, but higher level and lower level kind of got to be balanced, and in order to make change. And I as a legislature, being in the legislature now and being there for 2 years and seeing how things are done and how policy is implemented and how policy is not followed and how policy has gaps and all these other things. We're talking about high level things when we're talking about UNDRIP and reconciliation with Aboriginal people. But if we can't even get to the first step of making sure that the majority of our peoples are able to take part in affirmative action and equivalencies, and the standards are being lifted higher now to make sure that doesn't happen, to make sure that there's have to have 2 degrees for something that really is not necessary is I guess we have to, how would you address that in an overall aspect when it comes to Indigenous rights of all peoples in Canada, especially, because our Aboriginal people have always been sort of, everybody likes to say all these nice things, but they never do it. Okay, as a former chief, I listened to this and it sounds good. But we can sit around the table here for, and I'll be gone from here in maybe 6 years, and we still haven't done anything. So I want to know how is this change going to come about when no matter how hard we try as ordinary people to try and make change for our people, and the will is still not there, I guess. Thank you, Madam Chair.
Thank you for that statement and for that question. I can speak again from my experience working mostly with provincial and some federal government departments. One of the things that sometimes I've heard is the people that are charged with implementing policies, I don't know if we want to call them bureaucrats or government employees, sometimes I've heard the position that, the politicians come and go, but we're always here. And so this sort of resistance to change of just like, we're going to just keep going the way we operate our program, we're just going to continue on like that because today the politicians want it done this way, but tomorrow it could be another way, so we'll just kind of keep on, and I think that's where I absolutely feel your frustration of the challenge of getting change, and it's something that I'm sure keeps you up at night. It keeps me up at night. I respect your decision to continue and engage in politics to push for change. And I definitely agree that there's a feeling that we need less talk, more action. But I appreciate your question about how do we do that. Sometimes I think the answer can be simple as like, let's just take a step, right? Sometimes we want to have it all figured out before we act at all. And that may be appropriate, but sometimes maybe we start with a step. I think the other thing, if I come back to the Premier's question, I don't know if we necessarily need consensus or of everyone to be of one voice before we act. So I think a question would be, do you need all Indigenous peoples and all Indigenous governments in the Northwest Territories to be on board before a process begins? And I don't know the politics. I don't know how it works. It's a genuine question. Is there a small place to start, and how does that work? And I think if you're going to start, making sure that it doesn't have ramifications for people who aren't involved. I think my final component to the answer, which may not be useful, is I think people fear change. people know the status quo, and whether it's good or bad, it's known. And so sometimes it's just getting people to agree to change. And sometimes, that can be just a need to build trust or build relationships where you can trust what the other is going to do in this circumstance. I think can be helpful in getting people to start to take steps. But I think with most things, implementing the UN Declaration can start with some small steps, right? It may not need to be everything.
I was on mute. MLA Johnson, did you have questions?
Yeah, thank you, Madam Chair, and thank you, Professor Gunn, for your presentation. I guess I'd like you to expand on one of the points you made, is moving beyond the dichotomy of civil and political rights versus economic, social, and cultural rights. And when I look at, the declaration, there's obviously the questions of land and resources and FPIC, and that can become difficult, but I think there's a lot we are doing in the North and we can do on those economic, social, and cultural rights. Our Official Languages Act recognizes 11 official languages. We are constantly trying to run programs and working with Indigenous governments in cultural areas, and I think in many ways we're a leader in that. It's never-ending work to do, obviously, but when I look at some of the things we could improve on and make into a rights framework, I think those are them. But I think this is where all the lawyers have kind of have a huge disagreement in that Canada has never really had positive rights. We hesitate to guarantee someone a right to their culture, and because it's hard to implement something like that. But I think when you take a treaty kind of lens to it, there's many in the NWT still arguing that the government provided a right to First Nations for housing, and that's end of story. They could go to court if there's not housing, and that narrative still comes up. I know it still comes up on reserves across Canada with clean drinking water, that there was a right there, that a judicially enforceable right. Whether we're quite there is a different question, but I think it's certainly where we should be going. So that's kind of my understanding of some of the tension, but I guess I would welcome your input on how we actually implement, kind of these larger economic and social, cultural rights we see in the Declaration, beyond just government programs and funding, because that's not a right to me to have a program. Thank you, Madam Chair.
Thank you for that question. It's a really good one. I think, I guess when I think about economic, social, and cultural rights, we provide programs, but the governments don't necessarily take the position that they're required to provide those things, that they're always dependent on availability of budgets, of priorities. And so when we start taking a rights-based approach to social, economic, and cultural rights, it has to be part of the budget, right? It has to be provided. So we don't get to choose whether or not we provide housing this year or not, right? It has to be there. The program might look the same, but it really provides, I think, as you were speaking to, that safeguard. And I think the other point on this, the reason I talk about the interrelation between civil and political rights and economic, social, and cultural rights is particularly when we're thinking about Indigenous people's rights. A right to housing. Well, I could come up with an idea of what the right to housing, how we sort of roll out that program, but the right to housing may look very different for, I don't know, my spouse is First Nation, who's Cree, and I'm Métis from southern Manitoba, right? So we want to make sure that when implementing that program that Indigenous peoples are involved. And in order to ensure that, that's about that civil right to participate, that political right to participate in that decision-making process, right? So it's about developing and implementing rights with Indigenous people's participation. I think that's one simple way. It may also be about who is charged with developing and implementing the program, right? So self-government, for example, and self-determination may be that it's a partnership between the government of the Northwest Territories and an Indigenous government, for example. So I think that's sort of how I see that. And I think on the flip side to that, you're right. In Canada, we have long embraced civil and political rights and shunned economic, social, and cultural rights. And Canada is constantly I guess, warned by the Committee on the Economic, Social, and Cultural Rights that Canada is not doing its obligations, meeting its obligations, because the Charter, for example, that economic, social, and cultural rights don't seem to be enforceable in Canada. And it's funny how we've separated, because how do you exercise your political rights if you don't have a house, or if you don't have stable access to food, right? So how do you separate out those rights? How do you exercise the right to self-government in a way that's appropriate for the Indigenous nation if you don't have a right to culture and your right to your own customs, laws, and traditions, right? To make sure that that government is reflective of the Indigenous culture and of the particular nation. I'm not sure I answered your question, but I hope I shed some of my thinking on the topic.
Thank you. Mr. MLA Johnson, did you have a follow-up?
Yeah, thank you, Madam Chair. No, I mean, I think we all grapple with this issue. I think most of us would love to guarantee some sort of right to housing, and say if we go and do that through the declaration, and even Indigenous governments say they do it in a self-government agreement, we risk the broken promises aspect of we have rights in self-government agreements which can't be implemented because either we don't have the money or Canada hasn't, committed funding yet. And housing in the North, it would be a prime example. I personally believe people need to have a right to housing, especially in the North, especially Indigenous people, but it's a $1 billion problem, or it's a problem that, if we give people that right tomorrow, that it doesn't necessarily mean the tax dollars flow. And so I guess I have some hesitation in being very bold with UNDRIP implementation and, it becoming another document that is a broken promise, where it's full of grand rights and great ideas, and we don't actually have any money to, implement those programs. Which we've seen with modern treaties. We've seen a lot of modern treaties that, just haven't been implemented because the funding priority hasn't been there. And then it's probably going to take some of those governments taking us to court to, force that money out of governments. But I guess I would welcome any comments you have on that. The risk of, writing a very loftily implementation plan that doesn't have money behind it eventually. Thank you, Madam Chair.
Thank you, Emma. Go ahead, Matt.
Okay, thank you. You're right. I want to highlight one thing. The right exists. The right to housing exists whether or not a government recognizes it and whether or not a government fulfills it, right? We all have that right to housing, and even if a government is not able to fulfill it or chooses not to acknowledge it, the nature of inherent rights means that we have it. It just, we may be in a state of perpetual violation. But on your question on the funding, I think it's really good. I admit, again, to not being a politician. I do not manage budgets. But there's always priorities, right? And so under, for example, the Convention on Economic, Social, and Cultural, or the International Covenant on Economic, Social, and Cultural Rights, the ICASLR, the standard is the government is using maximum available resources. Right? So there's a recognition even in international human rights law on how you operationalize these rights. And so the question then becomes whether or not the government is implementing and realizing a certain right the priority that it deserves given the available resources. And I think that may be helpful. The other thing that I maybe naively believe is that once you make a commitment, it then becomes easier to justify allocating a budget in a way that fulfills those obligations, right? So some people maybe don't think government should be spending resources or allocating X number of dollars for housing. And one of the ways perhaps to address any pushback is to say, well, there is a human right. We are obligated to spend the maximum available resources. When we look at the budget and the different needs that we need to fulfill, this is the dollar amount that we set out in order to work towards achieving that result. Also on that point, especially in economic, social, and cultural rights, it's not an on-off switch, right? It's about a progressive realization. It's about taking the steps towards realizing those human rights. So no one expects governments tomorrow to spend all of its money to get everyone a house tomorrow, right? But looking at, are you taking the steps necessary to get there? Do you have a realistic plan? Is this a priority? Thank you.
Thank you, Professor Gunn. I don't think I have any other questions from other members. So I just have one, I just for myself, going through the presentation, listening to the presentation, and the comment that, there's a standard, like when you mentioned the standard of and health. So we operate on a standard of practice for many different on safety, and it's always risk-based. So when I think about implementing UNDRIP, and I think about the communities, and I think about the community that I grew up in and some of the surrounding communities, they're all, like you said, they're all so different. So how do you come up with a check mark box with standards that, that you can meet, especially when everybody's operating at different levels? And I know you've spoken to this, but I think that is where, as an Indigenous person from the territory, as an Inuit, not First Nations, not Métis, we're even in a different box than the rest of Canada. I always feel like when it comes to having discussions at the table. So where do we find this standard checkbox, or is there a checkbox standard that we are going to meet?
Thank you, Madam Chair. Again, really great questions. I'm really enjoying this conversation. Maybe the simple answer is it's not going to be a checkbox, right? And it may not even be a set of checkboxes for all Inuit, all First Nation, all Métis. It might have to be on a smaller nation to nation, and maybe even community by community. I don't know whether it's fair to expect all First Nations in the territory to agree, right? In the prairie provinces, we don't often agree amongst each other. And so part of my answer is I think we really want to be realistic in what we expect of one another, right? It's hard to get along. I mean, we don't get a federal government, 10 provinces and 3 territories to agree to much, right? So why do we expect for greater unanimity in amongst Indigenous peoples, especially when experiences, as you've pointed out, are so different, right? And legal regimes that have impacted communities and nations are so different that their responses and their needs and their aspirations may look really different. I think the other point that may be useful on the checkboxes is looking at that Indigenous navigator. I don't have it. I was going to see if I could pull it up, but I fear I may blow up the whole computer if I try to pull up a website and show the documents. But there is the Indigenous navigator. When you look at the, and maybe I'll include it separately as an attachment when I send in my PowerPoint deck. When you look at some of the explanations that are included, it's not a checkbox, but it at least gives you some indicators, like what is the standard, what are the rights, what are you looking for, and what would you see if that right is being implemented. And it's not sort of a checkbox, but there's definitely factors that sort of help us understand what those look like. And I think you're absolutely right that there will be differences, and I don't think the government should strive to have one plan for all Indigenous peoples, right? That it will need to really represent the diversity of Indigenous peoples and experiences in the territory.
Thank you for that answer. My follow-up to that is, we've had this discussion, and I know we've had the discussion as members. We've, as a committee, we've heard other speakers, and, it's come up before where you've said it, it's that fear of politicians giving away something, or if we move to this, then... And like I always say, they're working themselves out of a job, because the way I feel and I see is that, when we look at our Northwest Territories Legislative Assembly and we look at the makeup of the Aboriginal groups, is that who will be sitting around the Legislative Assembly in our future? Not us running in our ridings. It's the leaders of the Aboriginal groups. Like, is that a realistic picture? Or when we talk about and we hear from other things that these are not realistic, because the way where does government fit in, where does the government in the Northwest Territories fit in when we start implementing all these self-governments within our Northwest Territories? Not an easy question, but I don't know. That'll end everything.
Yeah. That fear of the unknown, right? And that I agree, that fear of working yourself out of a job, right? I don't know if it's realistic. Sometimes my answer is there's a lot we don't know about the future, but there's a lot we know about right now that isn't working, right? And just a short look at the statistics, right? From, as recent as the way in which COVID is impacting our Indigenous nations, at least in my province, the numbers I follow most, we are being hit. We are at risk in a way that's very different from the rest of the Manitoba population. The rates of over-criminalization, the rates, and I can just speak for my own province because I don't want to judge what's happening in the Northwest Territories, but the rate of apprehension of Indigenous children in Manitoba is horrendous. The communities that continue to be relocated due to flooding, the lack of drinking water and the connection to hydro in Manitoba continues to be an issue. Murdered and missing Indigenous women and girls continues to happen at rates that it shouldn't, right? So it's very easy for me to identify the problems. And so sometimes I think maybe it's better to think about what are the problems that we can all agree on that we need to fix than worrying about the unknowns of like what the future holds, because like there's just things we have to fix, right? And there's things we need to work on. And to the extent that the UN Declaration and the rights that it recognizes is a useful tool for us to address some of the challenges that we have, I think we should embrace it. And of course, there's unknowns. No matter, I mean, the best drafted legislation can still be subjected to challenge. So this idea that we need certainty is just, to some extent, it's a false hope, right? Like, we'll never know. People are still going to challenge things, but we do know that there are a lot of very significant issues and challenges that we face, and we know we have to start taking steps. And I think we can be confident that there's a way to move forward to start addressing some of these challenges without losing the positive gains that have been made where they exist, right? And absolutely, I mean, I'm constantly pointing to the Northwest Territories and some of the co-development. I think there's wonderful examples up north, and I don't think we should be concerned about implementing the UN Declaration as taking away from things that already work. That's not what human rights is, right? Implementing human rights shouldn't be making lives worse. So this idea that somehow we're going to kind of create situations where we don't know is hard. But there is an air of reality, I think, to your statement of implementing the UN Declaration may shift who is making what decisions, or at least how those decisions are being made. I mean, maybe all of you don't lose your jobs. Maybe it's just a bigger table with more seats at it, right? It could be, it doesn't have to be a give or take, right? It just might mean a bigger table with more seats rather than losing those that are there.
You're muted, Lisa.
Sorry. Do the members have any other further questions for Professor Gunn before we wrap this meeting, this presentation up? If not, then I'd like to thank you, Professor Gunn. And if you have any closing remarks that you'd like to make.
Thank you, Madam Chair. Maybe I just want to reiterate one or 2 points, and I really do want to sort of re-hit that. I think there are a lot of positive aspects to things that are happening in Northwest Territories, and I honestly believe that implementing the UN Declaration, including its intentions, means building on areas that is working and addressing areas where it's not. And I don't think there should be concerns that implementing the UN Declaration is going to detract from what's working, but it might require a realistic assessment of things that are working. Again, speaking of my own province, decision-making over resource development is not working. It's not working for our Indigenous nations in this province. And so, where things are working, and if they're meeting the standards, that's what you build on, right? Like, we don't always have to start from scratch. There may actually already be a foundation that can work from. And it really saddens me when I hear people doing fear-mongering kind of tactics of, we can't implement human rights because we don't know what it'll look like, right? Like, human rights are human rights. We're all entitled to them. And I think some people in Canada have better access and experience less violations of their human rights than others. And I think it's time that we start to take more steps in Canada to ensure that all peoples have access to and experience their fundamental human rights. So thank you again for your time, for your wonderful questions, and I'm happy to provide any more assistance that I can if you think there's more I can do to help you. But thank you very much for your time.
All right, thank you. And again, on behalf of this committee, I'd like to take the opportunity to say thank you. Thank you very much for your presentation today. It was a great presentation. We've had some really great presentations. So this concludes the public portion of our meeting, and I'd like to thank everyone who joined us through social media. I'd like to have a motion to go in camera. MLA Johnson has moved that the committee moves into camera. The motion is in order. We are now in camera. We're going to take a short 5-minute break just to allow the disconnection of the live stream. Does anybody have questions for Professor Gunn while we're in camera?